request Justice Victor Chalaya to give his closing comments. So only one point I thought the number of people have mentioned is about expensive justice and then the lower judiciary reforms, etc. Of course, I don't know whether we'll be able to cover all this in the session, but if you have your views on this, people will be happy to hear you.
Mr. Krishnamurthy, this talk was confined to the role of the Supreme Court as the sentinel of the Kiwi. But you have provoked me to say something about the judicial system itself. I think we could perhaps have mismanaged our affairs better. And the kind of technological developments all over the world, sooner or later, we have got to sit down and analyze the trial system and the subordinate courts and the work culture of the courts. Possibly, there's a recent writing by a scholar by name Richard Susskind. He said, online courts, future of justice. Now the work in the tribunals in England, most of it is online. And the court management, case flow management is so excellent that at one point of time, from the magistrate or the trial court to the House of Lords, it takes 7 years. Now it has been brought down to 3.5 years. It is possible in India that if you plan it properly, exploit the technological development that have occurred, and perhaps the introduction of artificial intelligence. Perhaps if you manage it better, I think in about have some 3 years' time, put it on an assembly line. 90% of the cases can be disposed of in 18 months. And in the first 3 years, in the next 3 years, 95% of the cases can be disposed of within 12 months. Of course, 5% of the cases are sticky business. They will take their own time. You can't prescribe a time schedule for all cases uniformly. Possibly some 5% of the cases remain that way. The interesting thing is, out of the 35 million cases pending in the subordinate courts, 50% of them are in 5 states. Just 50% of them are in 5 states. And if you set up one district as a stereotype mechanism to handle the case flow management, possibly things can be solved. I think people are now applying their minds to the potential of the new scientific developments and the communication systems. And possibly, I expect, out of sheer pressure of the public opinion, within a year's time, a model will come out. And I'm quite sure that the trial system will be revolutionized if some of the potential of technology is harnessed and utilized. Work is going on, and it's a very interesting book. Almost the tribunals in England are virtually 70 to 80% of the work is online. It's a very interesting thing, and there is a great potential of technological exploits in their application to judicial system, particularly in the trial stage.
So thank you very much, sir. And Sucheta, would you like to take 1 or 2 questions, or depending upon, yeah.
Yes, so we have a galaxy in the audience, and I think, we'll take just a couple because it's been a long session. So, Arvind, you want to?
Hi, ma'am. Can you hear me?
Yeah.
Yeah. So, ma'am, we have received a question. Actually, Shailesh Gandhi sir has also shared a question of his. So I'll just go ahead and share that.
No, let's
Hello? Yeah, yes, ma'am. So I was just going to request if he could also unmute. Gandhi sir, can you please unmute? So we can hear you, sir. You left. Hello.
The question, sir, is there are two kinds of positions Supreme Court takes. At times, people say the court makes the law. At times, it is said the Constitution guides. My simple question is, if the Parliament makes the law, in my opinion, it can be struck down on the basis of not being in consonance with the Constitution. But short of that, is it okay for the Supreme Court to give its own meaning to laws which was never intended by the legislature or the words of the law?
May I request Justice to...
What is the question? May I understand the thrust of the question?
Mr. Shailesh, would you like to repeat or summarize the question, please?
Yes, sir. In simple terms, lawmaking, in my understanding, is the job of the Parliament. And it's the Supreme Court's job to interpret it if there is a difference in words. But I think number of times, though the law is very clear, the Supreme Court says we make the law and therefore what we say is the law. Is this right?
Yes. Thank you for this. Thank you for your question. This is an old question which is being raised every time when a judicial exploit in terms of serious decision is undertaken by the court. Normally, judicial work is about a pending dispute, a dispute that already exists. For example, there is a statute. The rights and liabilities of the parties concerned in the administration of that statute already exist. Therefore, that is a judicial duty to resolve any dispute that arises under a statute. But in a constitution, it is not what exists, what might come up in future. And any decision of constitutional interpretation is not mere adjudication. It has an essential legislative element in it. And that is what is called the judgment law. Somebody said, how can judge make a law? But when in a precedent-ridden court, for example, the judgment that is rendered today will be binding on the subsequent cases in the High Courts and the Supreme Court itself, unless it is overruled. And that itself is, the judicial process itself inevitably involves a legislative element. That is what's called the judgment law. And it is inevitable. And this question was put to Lord Reid. He said, we don't believe in fairy tales anymore. Judges do make law. Because in the very legislative process, the judicial process itself, the moment you decide, that becomes a precedent in the next case. And in Constitution, the judgments that you render are not deciding a pending single dispute. It is a matter concerning the future. Therefore, essentially, that is the sense in which law is made by the court through its decisions. This is my understanding of it.
Thank you very much, sir. Arvind, any more question?
Yes, sir. There is one question that we've received from a student, Ms. Poonam. This question is, judicial activism sometimes is criticized by calling it judicial outreach. Hence, her question is this: if in a large democracy like India, the provision of separation of power between different organs of the state legislature and the judiciary, is it practically workable?
Please tell me what's the ultimate formulation of your question?
So the question is in a large democracy like India, is it possible to separate the different powers of organizations like the legislature and the judiciary? Is it practically a workable solution?
Thank you for the question. this is the essence of the subject matter of today's debate, namely, is the Supreme Court a sentinel of the Kiwi? That is, to protect the rights of other departments of government, of the state, executive. We must know when judges begin, the old English statement was, would rather be, the British will not tolerate to be administered by the judges as they don't tolerate to be legislated by the executive. The essence of the difference is that the purpose of judicial adjudication is not merely to exercise judicial power, but also to see that other departments of the state, namely the legislature and the executive, function within their bounds. Therefore, the work of the Constitutional Court is to reconcile the possible conflict between legislature and the executive and the judiciary, legislature and the judiciary. Therefore, this is a court which has to consider a constitutional provision. It is not merely interpreting it, it is expounding it. It is called expounding the Constitution, because any judgment of the court explaining the scope and the import of a constitutional provision has an effect on other departments. The essential thing is the coordination will come in when a fundamental right and its dimensions are expounded by the Supreme Court, law is laid down. Then systems must be built in by the executive and the legislature. Incidental supporting legislation may be necessary. And all this kind of thing is a matter of coordination, which has at the heart of it the effectuation of the guarantees of the people, guarantees the Constitution gives to the people. Therefore, it is a kind of a coordinated effort. Supposing the court goes beyond the constitutional limits, the legislature can overrule the judgment. It can pass a legislation. We have any number of instances in India where the Supreme Court judgments have been overruled by legislative overruling of the judicial judgment by amending the Constitution if necessary, or amending the law if necessary. And this is the balance that is, that's how a constitution must be worked. It is expounding a constitution. It is not interpreting a provision in the constitution for the time being. It is a process by which the system grows up in coordination. That's how it works, and that's how all the experiments of all democratic constitutions. Of course, England doesn't have a constitution excepting the Human Rights Act, where you can't strike down a law. In fact, it used to be said that as students 70 years ago, we would be hearing the first proposition of the supremacy of the British Parliament. If the British Parliament said all blue-eyed children should be drowned in Thames, that's a good law. Nobody can interfere it. But even there, the question arose in early part of the 17th century, I think in 1603, in a famous case called Dr. Bonham's case. If the legislation runs against the justice of the common law, the court can strike it down. That is how they construed it. And this is a work of the genius of the judges and the willingness of the administration to understand the import of the judgment, and the willingness of the alertness of the legislature. If it finds that the court has exceeded its limits, it can use its legislative power to bring it in line. This is a matter of constructive approach to the working of the Constitution by all the agencies responsible for the working of the Constitution.
Can I request Madam Indra Jaising to give her closing comments?
I think it's very interesting that on this panel, we have straddled three generations. From the generation of Justice Venkatachalaya to my generation, and then to Justice Sikri's generation. So I think the points of view that we have seen represent virtually the history of 70 years of functioning of the judiciary. And so the only really closing comment that I'd like to make is that we should not be judgmental about anything for that matter. We should look at things in a historical context. And we all know that history must be studied in order that it's not repeated. At least the faults of history are not repeated. And it has always been a very great pleasure for me to have appeared before Justice Venkatachalaya in court. I have argued extremely important cases in his court, including the Bhopal tragedy, and I'm deeply aware of his learning, which I think is a national treasure for all of us. But I'm happy that despite the fact that we belong to so many different generations, we've been able to converse with each other in a very dignified manner. Thank you.
Thank you very much. Thank you. Now, may I don't think there is any other important question. Mr. Arvind, would like to take it, or we can go for the vote of thanks?
So with this, we come to the end of the third RTI Annual Lecture. The comments show that this has been an extraordinarily enlightening couple of hours. We're deeply grateful to Justice M. N. Venkatachalaya for his words of wisdom. He has shown once again why he is called the Bhishma Pitama of the Indian judiciary. Sir, we are especially enthused at your prediction that technology can end judicial pendency to a great extent in 18 months. In saying this, far from being extinguished, you have shown that you're way ahead of many who are on the bench today. We, the ordinary citizens, are most concerned about the turmoil in the judiciary and the system of justice. So I'm deeply grateful that both Justice A.K. Sikri and Madam Indra Jaising did not hesitate to address many of the concerns that all of us had and took them head on and addressed them. There were a lot of expectations from today's program. This is evident from the extremely distinguished audience we had today. We have had among us today senior and very respected judges, respected bureaucrats, activists across the spectrum, lawyers, doctors, concerned citizens, even Super Cub, Mr. Julio Ribeiro. And we couldn't have done better than having Mr. Krishnamurthy, who's been such a role model for all of us, to preside on this event. I end today's evening with a special thanks to Dinesh Thakur and the Thakur Foundation for having made this program possible. Thank you all for attending, and good night.
Thank you very much. Thank you, sir. Thank you.